I'm Emmanuel Howard for Walter Emeny. This is a case that was totally tried on circumstantial evidence. There was no eyewitness. No one saw Emeny or anybody else enter or leave the house on November 19th, 1985.
Well, you'll agree that circumstantial evidence can be enough to support a conviction.
If it is enough, and that's what the first issue that was raised in the brief was, that the evidence was insufficient. And the standard when circumstantial evidence is presented is that there must be no other reasonable explanation of the facts proven, and the evidence must be inconsistent with innocence. That
well, then let's talk about that box that the ring was in. The ring?
Yes, the ring box, sure.
Because that's the basis, isn't it?
That was theoretically the new thing that I should say that came up after 20 years.
The daughter said that her mother gave her some jewelry, and it was in a box.
Yes, yes.
And the daughter says she went to school,
yes,
and when she came home, her mom was dead.
yes.
And the box was found in the defendant's possession.
A box was found in the defendant's possession. That box was the same type of box, according to the witness, who's the Act 2 representative. Her name was Marilyn Dera, said that in testimony at volume 8, page 63, that these things were packaged like that from 1971 to 1986. They were, so this implies a catalog that was out at that time, being sold at that time. The ring could have been purchased at any time. There was nothing else distinctive about it except the style. There was no evidence given by Ms. Dara or anybody else of the size of the ring. There was no evidence of which size ring the victim had on any of her fingers.
But wasn't a box having that number on it in the victim's apartment on the morning that she was killed?
That's not the testimony that Alicia gave. She said that was a box. She didn't mention specifically 673 dash whatever it is for size.
Okay, but was there such a box in the apartment after the police arrived?
No.
Okay.
Now, the picture that was taken, now the daughter identified this when she was an adult, and she did it on the basis of a picture that was taken when? Immediately after?
1985.
1985.
Yeah.
And that picture showed the box.
Picture showed the bottom of the box. No number that I could see, and it was among. It's in. We have record page 417. It shows an evidence bag photograph, and it shows the bottom of the box, because you can see it's the bottom of of a box. That's just nondescript.
But that's what the daughter recognized, right?
That's what she says. That's the box.
And she also testified that it was the box that it was jewelry that her mother said was just purchased, that she was sharing because of this special day and the bad hair day and the pictures and all of that.
Right, yes.
Right?
She
so
said,
connecting the time frame, wasn't this broad time frame that you described when this type of box was being used by Act 2. That was the, right?
She says there's a box. So if there's a box, that doesn't exclude other 673 boxes from being in Emeny's possession at or around the time after the victim was killed. Because that was, the point is that was in circulation, in mass production, the same box, for 15 years.
Well,
And
that doesn't make it inadmissible. It
I
just
didn't
goes
say-
to the weight of it, right?
Absolutely. I didn't say it was inadmissible. We're just, I'm answering your questions about circumstances, and we're addressing here, there must be no other reasonable explanation of the facts proven, and it must be inconsistent with evidence.
But could I just follow up a little bit on
Yes,
that
ma'am.
very important piece of evidence? Because there's further evidence from the defendant's own statement. I believe, I'm not reading from the redacted portion, but from the admitted portion. You'll have to clarify for me.
Sure.
Because I read them both. Was that this was part of a purchase. He was wearing a ring that he said matched that of the victim, and that this came as part of a purchase, that she bought jewelry, and there were two items you could buy, and the third one was half price. First he said, she gave it to me, and then he says, no, not really, she didn't give it to me. I gave her the money, and she bought it. So he's not even saying there, and I bought it, to explain the box. He's saying she bought it, right?
He's saying that she bought rings.
Right.
He's saying that she bought rings.
But on the piece of consistent with innocence.
Yes, but he doesn't say that he didn't buy other rings for other people because he was familiar with the Act II program, and he could have, again, on the basis of exclusion of other reasonable explanation, he could have purchased the same ring for somebody else. And let me address a suggestion about taking that ring box out allegedly after the murder, and the Commonwealth pointing to Emeny and says, look, he took the ring box so that no one would know that he had a romantic relationship with her. But there was other people who knew that. There were several witnesses who testified. Some arrangement, the victim's girlfriend, the employer, a co-employee, all testified that. He even mentioned it himself in his interrogation, which was before the jury. So I'm just addressing that point. The point is that when I'm saying there was nothing, no traces, no eyewitness, and
But what's he doing with the box if she had bought the ring?
that could be another box that he bought. That's what I'm saying. That's what I'm suggesting. That could be.
Was there any evidence that he bought a ring for somebody else?
No.
Well, so the only evidence in this case is that she bought some rings with money that the two of them had pooled. The box happens to match the ring, and it's in his car.
That box does not necessarily match that ring. No, but he didn't testify of what rings he purchased with her or for her. He didn't describe those rings. He didn't say that this is a garnet ring, this is a mother-daughter ring. They were mother-daughter rings. So again, reasonable explanation, she bought mother-daughter rings, the victim, not Emeny would have bought a mother-daughter rings. These were birthstones, matching her birthstone and the daughter's birthstone. So when going back to this, the explanation of the facts proven, that comes from Webster, and that leads to another old case, but a illustrative opinion about the prejudice and dangerousness and the unfairness of letting cases go to the jury when these standards are not met. I'm speaking of Commonwealth versus Merrill, 14 Gray, 415, at 417, 418, 1860. And there the charge was assault on a young girl with felonious intent to have carnal knowledge with her by force. That's how old the case is in that way, against her will. And the subject was criminal intent. And the court spoke that it was necessary that the acts of the accused be shown that there can be no reasonable doubt of criminal intent. Here, identity. There can be no reasonable doubt of identity, because that's the only live issue in the Emeny case. If these acts and conduct were equivocal or equally consistent with the absence of felonious intent charged, then it's clear that they were insufficient to warrant a verdict of guilty. And now I would like to emphasize, as the case was left to the court, left by the court to the jury under the circumstances and under the instructions that were given, they were at liberty to infer that the evidence was sufficient to warrant them in finding a defendant guilty of the aggravated charge here. Now, in the Emeny case, the danger of letting the case go to the jury on equivocal and nonspecific circumstances is that they will be exposed to unwarranted consciousness of guilt by flight instructions, and then be allowed to consider improper but unobjected to evidence, such as the Sixth Amendment and Article 12 violations in stating of the autopsy facts by the substitute pathologist. The original pathologist had since passed away.
But I take it that the cause of death is not at issue here.
Absolutely not.
The only thing at issue is whether your client did this or did somebody else do it.
Correct. Correct.
So the fact that the doctor, it was not objected to, and it was not an issue in the case.
It was an issue in the case
Not
because,
a tested issue in the
yeah,
case.
it was, yeah, Justice Gordy, it was an issue in the case in this respect, because the facts, among the facts stated word for word from the autopsy, Dr. Evans was reading from Dr. Katz's autopsy, were measurements of both the length and the depth of the knife wounds. And then those measurements, shown undisputedly, were faulty because the autopsy pathologist did not follow prescribed practices for reconstructing wounds. And that's in Spitz and Fisher, undisputed authority on
Was there
pathology.
cross-examination on that point?
Excuse me?
There were photographs showing the nature of the wounds and also some testimony from the expert regarding why you couldn't always get exact measurements because things stretch, et cetera. So was there cross-examination? I didn't read the transcript on that.
He couldn't cross-examine. Mr. Muse, the trial attorney, could not cross-examine Dr. Evans about the faulty, and wouldn't cross-examine Dr. Evans about the faulty procedures of Dr. Katz's. Dr. Katz's would get on the stand. That's a different story, and I mentioned that in my brief. If he, but
you can
point.
impeach hearsay on any basis. And
Excuse me.
it's not an important point. I'm sorry,
Okay.
I interrupted you.
The cases that go down and that I cited extensively in the brief talk about a substitute pathologist stating facts. He stated facts. And the reason for the precision in that is that he then was allowed to submit a diagram that he took right from Dr. Katz's autopsy. They submitted the autopsy itself. They submitted unauthenticated autopsy photos, and these were all, but the facts were based on a flawed autopsy, and then the harm that comes into it is this, that this was, the judge permitted an exemplar of a buck knife to be submitted for the illustrative purposes. This is a buck knife, and you can look at this buck knife to understand the testimony and so forth and so on, understand Dr. Evans' testimony. But the buck knife has got dimensions, and the buck knife is tied in to Mr. Emeny because he had a buck knife at one time. He says he lost it. And that buck knife became the personification and stood in for Emeny and stood in for the absence of eyewitnesses.
Was there any testimony about whether Mr. Emeny's buck knife was of comparable dimensions to the exemplar that was admitted?
No, they said this is what a buck knife looks like.
Oh, so all buck knives are by definition of similar dimensions?
I don't know.
But there was no testimony on this point?
No.
Was the sheath introduced?
The sheath was he carried. Yes, the sheath was introduced. It's in evidence. The Commonwealth split it and showed an indentation of what's called a buck knife.
So couldn't the jury examine the sheath and determine for itself an approximation of what the length of the blade of the buck knife owned by the defendant?
This is not the length. This is the depth of the blade. And you have to do the...
Well, that's what I mean, the length of the blade.
Yes.
Couldn't you figure that out from looking at the sheath and the impressions in the sheath that were made by the knife that Mr. Emeny had?
That would be an undue stretch, an undue influence.
Well, how much of a stretch would it be?
Because there's...
I mean, could they mistake a 6-inch knife for a foot-long knife, or a 6-inch knife for a 7-inch knife?
No. Excuse me. This isn't the length. This is the. In other words, this isn't the depth of the wound. This is how long.
The width of the wound.
Yeah, this is the width of the wound. Mm-hmm. The width of the wound, but he calls it length. Dr. Katzis calls it the length of the wound. In other words, on the skin, from this point to that point, measures X number of inches. That's what Dr. Katzis says. He didn't reconstruct it, and there's a difference because there are different width knives, and a kitchen knife was found, and that wasn't excluded. That's why there's a. Forgive me for saying it this way. But there's a bait and switch. There's a kitchen knife that was found, supposedly with occult blood, in the kitchen itself. No trace to anything else, just occult blood, meaning it's blood on it, we don't know where it comes from.
In the sink?
In the sink, yes.
And that's where there was other blood in the sink too?
There was blood in the sink, and there was a bar of soap with blood in the sink. And there was another.
So is the inference that whoever committed this crime washed their hands in the sink, and the kitchen knife was in the sink, and the blood could have gotten on the blade of the knife that way?
Yeah.
Okay.
And then there was a serrated knife found on Avenue A in front of around Ms. Brady's house. She was a witness who talked about seeing a red and white car. She was 15 years old at the time, but they found that, they tested it. There was nothing about it. And in Spitz and Fisher, it says that you can't tell what kind of a knife caused the wound. If it was a serrated knife, it could have caused the same wound, and it would have looked the same to a pathologist.
Mine is recalling, wasn't there a specific agreement that there wasn't going to, not just a tacit agreement, but a specific stipulation that the defense wasn't going to be challenging width and depth of wounds?
If there was, then that was a mistake. I don't think there was. I don't think.
But wasn't that the basis of the agreement not to introduce the internal autopsy photographs? Is that there was a stipulation?
And if if he missed that, then that's involves, especially under the cases here, a substantial likelihood of miscarriage of justice, because there was nothing else logically to tie Emeny into this crime. And I know the light's flashing, but I just wanted to make sure that the court understands that there was no evidence of any violence between them. There was no evidence of any threats or any disparagement that was made on Mr. Emeny's part.
Well, she
towards
complained to the
witness.
employer that he was hanging around and bothering her,
hanging around.
and he refused to obey the employer's command to stay away. And
No. He was somewhat smitten with her. This is not unusual, and there's a reasonable explanation for that, and that doesn't tie into a motive. This unrequited love is again a stretch that just breaks the rubber band as far as in my opinion, and that's what I submit to the court. And thank you very much for your attention.
Thank you, counsel.
Thank you.
Good morning. May it please the court, I'm Marion Ryan, Middlesex Assistant District Attorney, representing the Commonwealth. With me is Assistant District Attorney Ann Pogue. And as we speak to the facts, I would point out for the court that I was the original prosecutor assigned to this case in 1985, and I tried the case as well in 2007. I would suggest turning first to the defendant's argument with respect to the circumstantial nature of this case. As the court has already indicated, cases certainly may go to the jury on purely circumstantial evidence, and as the court stated in Commonwealth versus Linton, it is only required that those inferences to be drawn from that evidence be reasonable and possible. There is no need that they be necessary nor inescapable. And I would suggest to the court that the Commonwealth in this case presented a very strong circumstantial case that pointed in one direction, that was to this defendant, and it pointed to the guilt of this defendant as to the murder of Patricia Clark.
Let me ask you this, though. Did the evidence wasn't this essentially the same evidence as there was in 1985?
Without the primary new piece of evidence was the discovery that the box was in the car. What occurred was, when the defendant was stopped at the rest stop in Sturbridge, it was determined that he was essentially living in his car. His car was filled inside the passenger compartment as well as the trunk with all sorts of debris, clothing, all of those things.
This was back in 1985.
In the tow yard in 1985, a state police photographer carefully photographed all of those items in the car in their original location, inside and in the trunk. One piece of evidence that was known to be significant at that point was the finding of the newspapers, the city edition of the Lowell Sun, which were in the back seat of the car. Those being for November 20th and November 21st, 1985, could not have been purchased anywhere but downtown Lowell.
And his statement was that he wasn't there. He was
Correct.
someplace else.
Nowhere close to where they could have been purchased. The state police photographer also photographed in separate sections the trunk of the defendant's car. Those photographs appeared to have no particular significance. There were fast food wrappers. There were all sorts of things thrown in there. Items from that trunk were preserved, including the knife sheath and other items that appear in that plastic bag of evidence. Alicia Clark, at the time, was 11 years old. Obviously was available for a very limited amount of questioning. Having the trauma of coming home and discovering her mother, the family essentially fractured after that. She was moved around. There was very little contact between the police and Alicia after those initial interviews, and then she was placed in the custody of a variety of other people who did not make her available, and it was determined that it was in her best interest not to be extensively questioned. When she became an adult, as the investigation had continued, and she had reached back out to the police, there was an attempt being made to have her actually, what she was there for, was to identify a set of keys that had been found in the defendant's car. We had never located that missing key that was taken from the teacup on the windowsill. There were some keys. When she was, at that point in her late 20s, she was asked to come in and look at some keys. She did that. In the course of that, those keys were presented on photographs on a computer as well as that bag with that evidence. At that point, Alicia on her own said, that's the box that the ring came in. That box bears a little sticker on it. You can't see it in that photograph, but you can, on the side of the box, it has that little sticker that bears the number 673.
Did she actually examine the box?
Yes, yes. And she knew that box to have been part of this packaging that had been in her home when she left to go to school that day. We then began the process of identifying that box as matching to the ring that her mother had showed her that morning, which in fact she still had in her possession, had kept all of those years, and gave to the police so that we were able to have the ring. The ring matched the box. We got the catalog that showed the ring we had was the ring pictured in that catalog. So that was the new piece that helped us now to put together all of those pieces that we developed before.
Okay.
I would suggest that with respect to that, counsel argues that there might be some other explanation for that. That's certainly possible, but that has to be taken in terms of the evidence as a whole. In the evidence of a whole, the explanation is that the defendant was in the house on that morning after the bag had been opened, that he knew that there had been an exchange or an attempted exchange of rings, those being tiger eye rings, from Act 2, and that he feared being implicated by the finding of that box. There was absolutely, it was a cardboard, not even cardboard, really a paper type box. It had absolutely no value. It was empty. There was no reason to have that particular box other than to have removed it from the scene. It both undercut the defendant's story that he had not been in the area, had not been in the apartment after the 18th, because Alicia testified that her mother was opening up those items on the morning of the 19th before she went to school. And it established, in part, the motive, which was the unrequited attempt to be engaged to Miss Clark, in which she had rebuffed him. And that there had been some evidence that at least one friend, a friend who was deceased at the time of trial and did not testify to that, knew that there'd been the offer of the ring.
Now, in 1985, you found blood in various places,
Yes.
evidence of blood in various places, including in his car, on his hands.
Yes.
Was that blood ever subsequently examined more carefully
Yes.
for DNA?
There was an attempt to do STR DNA testing on that. That's what chemist Lally testified to, that by the time that was done, the lab could not do that in 1985. By the time they were able to do it, which I believe was approximately 2003, because this was an ongoing investigation, the evidence had degraded to such an extent that it was insufficient, although what they were able to test did exclude this defendant as the source of the DNA that was recovered from under the victim's fingernails. So that was advantageous to the defendant. And that was, in fact, Commonwealth would submit the basis for permitting chemist Lally to testify, because much of counsel's argument at trial was there is nothing, there are no forensics that link this defendant to that house. There's blood.
So what did the chemist testify to then?
The chemist testified that
Couldn't do the analysis?
that it was that it was her opinion. They couldn't do the analysis of STR, the further, more sophisticated analysis, and it was her belief that that was due to degradation of the sample in the 20-year plus.
But they were able to do the analysis of the fingernail.
They were able to do enough to exclude the very simple testing that, in fact, excluded the defendant as the source. They established, obviously, the victim's own DNA under her fingernails, as you would expect. They excluded the defendant as the source of any other debris under the fingernails. They were not able to do the further testing on the blood in the sink, on the soap, or on the, it was only occult blood in the defendant's car, on the steering wheel and on the gear shift.
And did defense counsel argue that in closing that that blood under her fingernails excluded the defendant, so there must be some third person that was involved?
He argued extensively that there was no, his whole argument was there was nothing that linked the defendant to the house on November 19th. No forensics, no hair samples, nothing. That one would, sort of the attempt to portray that in the CSI world there was none of that put him in the house on November 19th. With respect to...
Just a clarification, the
Yes.
debris under the fingernails, it wasn't necessarily blood?
It was not blood.
Right, that's what I thought.
Yeah.
And there was further testimony that it could have also been her own?
Yes, the chemist testified that one always finds one's own DNA under the fingernails, and then there was any number of other debris. That was not positive for the presence of blood.
So there wasn't a third-party cult for defense? Is that what you're suggesting?
I don't think on that alone, no.
Okay.
No. The defendant's argument was based on the totality of the Commonwealth not having a link, a forensic link to the house. With respect to the testimony of the medical examiner, I would suggest, as the court has already pointed out, cause of death was clearly not an issue in this case, that the Commonwealth was prepared to offer autopsy photographs to show both the nature and depth of the wounds inflicted. There were horrible injuries. There was an injury that actually severed the spinal cord of Miss Clark. That the defendant did not want those photographs to come before the jury, a wise tactical choice, given that the cause of death was not an issue. That the stipulation was that he would not object to the testimony by Dr. Evans as to depth and track of the wounds, and the Commonwealth would not offer the internal photographs from the autopsy.
And I take it that there really was no objection at all to the testimony of the medical examiner, was
No,
there?
there was not.
Nor was there any cross-examination for that matter?
And I would suggest that that was a reasoned tactical choice, given the nature of her injuries and the issue at trial, which was solely identification. I would suggest that based on all of the evidence that was presented in this case, the Commonwealth presented a very tight and strong circumstantial case, that the trial judge carefully limited the type of evidence that was admitted, that evidence from the experts and others was properly admitted, the instruction that was given that the defendant challenges the consciousness of guilt instruction was carefully crafted, virtually identical to the language approved by this court. It was certainly warranted by the evidence of the defendant's flight from the area, and there is no basis that exists in the record for any relief for this defendant.
Can you explain to me the evidence about a car seen leaving the area?
Yes, sir.
I take it that was fairly important. Doesn't that lead to actually the discovery of the car? I mean, explain to me what was seen and how that evidence played out.
Yes, sir. The victim and her family lived in a housing development in Lowell. The housing development was essentially built like number 3. It was in loops on top of each other. She lived in one loop. There were loops, another set of loops below that. Christine Brady, who was then 15 years old, lived in the loop below the Clark home. So when you left the back door of the Clark home, which is the way that the killer would have had to leave because the body was blocking the front door, there was a large open field, and that brought you down to the next number 3 loop of apartments. Christine Brady testified that she at that point had a crush on a boy named Scott, who had a car that was almost identical to the car that this defendant drove. She was also friendly with the Clark family, being the same age as one of the Clark children. She knew that the defendant was a boyfriend, as she understood it, of Miss Clark. She knew his car was in the area, and that she, because she had this crush on Scott, was always on the lookout for this, what was a fairly distinctive, very big, very bright, candy apple red, kind of fins, white roof car with some antenna on the back of it. That was similar to Scott's car. She was always on the lookout. That there was a difference, although she was not really able to articulate what that difference was, between Scott's car and Emeny's car. That on this afternoon, she was home from school, that her sister, her older sister, had come into the room, somewhat taunting her, saying Scott's car is coming down the street, which would have been the street behind Miss Clark's home, above the Brady house. She ran to the window. She looked out in anticipation of seeing Scott, saw the red and white car, but was able to determine that that was not Scott's car. It was being driven by a man, and it disappeared in a way that would have taken them out of that loop onto the highway.
And that was close in time to when the murder happened?
Early afternoon was the best she could do. Yes, it was before the school bus came back.
And the information about that car, did that have any consequence later on in the investigation? In other words, was that the basis on which they ultimately identified the defendant's car? And
it was not, Your Honor. The Lowell police, based on the interview with Christine Brady, did issue a BOLO, a be on the lookout for that car. There were no responses to that. Okay. Completely unconnected, Trooper O'Grady, who had not seen or known about the BOLO, happened to find the defendant in that car in the rest stop. The car was running because it was late November. He had testified that he'd been trained. They were always concerned about suffocation, that they go window to window and knock and just make sure that everybody's awake. He did that. I'm sorry.
But that car and its identification does tie significantly to another issue, another piece of evidence, and that's consciousness of guilt, right? Because
Yes.
you did need that, right? That's in order to connect it to activities following that you were able to elicit from the defendant as to where he went
Yes.
on what day, specifically where was he on the 18th, 19th, and 20th, correct?
Correct.
And I tried to follow the admissions. I'm not sure, maybe this is incorrect. It says that he admitted he spent the night on the 18th through 19th in a motel in Vernon. I'm not sure he did, but in any case, there was evidence about him being at a hotel, and there was evidence, some in his exculpatory on his part, and others that indicated he left.
Yes. He was attempting to say, we had evidence that he had been in the hotel in Vernon. The slip that he had, on the slip that he had filled out, it was actually a paper slip that he filled out to rent the room. He put down the date of November 18th.
Right.
It was actually the 19th. The clerk had told us that, we had evidence from the clerk that it was actually November 19th that he came in. The implication being that he was attempting to establish an alibi that he was down in Connecticut on the morning of the 19th and could not, which of course was inconsistent with what he later told us about, I went to Boston and tried to pick up my probation record.
One thing I wasn't entirely clear about from the briefs, was there any evidence at trial that the defendant had a license plate that was a proper license plate for his red and white Monte Carlo?
No. He had testified that at some point he had failed, I believe, to pay excise tax, and that his plates had been revoked, and that he then had begun using his sister's plates on his car, and that had continued for some period of time. And those were the plates which caused the trooper O'Grady to issue him the citation.
All right, so when the notice went out, the notice to be on the lookout for the defendant's car, was there evidence that it was that it bore a license plate different than the one that was actually on the car?
My memory is that there was no information about a license plate. It was a description.
So the only evidence was that when the trooper who saw the car at the rest stop in Sturbridge checked on the defendant's well-being, he ran the license plate, and it did not come back to that car.
Correct. That was, and he at that point has no knowledge that any license plate or any car is in play.
Right.
He doesn't find that out until the next morning. Okay. I would, just one additional matter, I have filed with the court today a motion to strike affidavits of Mr. Muse, as well as a letter from Mr. Muse that are contained in the defendant's reply brief, and the reasons for that are set forth in the motion.
There was no motion for new trial in this case?
There was not, Your Honor. Thank you.
Thank you.